Welcome back. Ready? Okay. Welcome back. Welcome back. We are now at class 13. We are roughly halfway through the semester. Once again, coming up with midterms soon enough. I encourage you. When's your next Langdell session? This week, right? I encourage you to go. I think John Paul will be going over our midterm from last year. Now, you've already taken my midterm, so you know what to expect. The rules are the same word limit, same length, same number of questions. It's identical, but we'll be going over the midterm from last year. It should help you out a bit. Okay. By the way, let me ask you a question because I have you here. I find the midterms most helpful for the 1Ls and less helpful for the 2Ls with the 1L class. Do you all agree with that? Okay. So if indeed, now this is not going to help you. This is for your future colleagues. But if indeed property and con law are kicked towards the 2L, could the midterm be dispensed with? No. You want to keep it? All right, raise your hands. I'm open. I don't have an opinion on this. What do you think? Well, Marcus, what?
I said no. It forces me to make an earlier outline. So yeah.
So you think even 2L midterms still work?
Yeah.
Okay, Kendra?
I like that if you haven't had the professor before, you like learn their style of their exam and grading and stuff.
So if you've had the professor before, it's less useful. Still, you want it. Okay.
I think midterms are really helpful to like judge whether you're at or you're understanding.
Even as 2L. Especially, oh, okay. Who else? I saw a few other hands. Yeah, our meeting's today at 4 o'clock, so after this I'll be talking about this. All right, that's actually good to know. I had assumed people in the utility don't want to deal with this crap anymore, but if you want it, then that. All right. Okay, fair enough. All right. Any? Oh, Brooke, what's your hand up? When you say grading, it doesn't count. The way I do it.
Yeah, the way you do it. Are you still going to like meet with them, or are you going to not? Because I feel like for me, it's only helpful if you actually meet.
No, if you do the midterms, I think after the meetings, it's one and the same. Yeah, I mean it's a significant time commitment to the 1 hour the one-on-one meetings, but if you think it's helpful, then we can keep doing it. Okay, good to know. Just because the way our system set up now is you're not required to give a midterm. You're expected to for the 1L classes, but I didn't know how it would shift if the 1L classes kick to your second year, which is basically you'll be taking required classes until your fourth semester, which is kind of strange. Okay, anything else? Okay, so let's do a question to start, and this will help bridge our reading from last week to this week. So the question is this. Let me put the polling thing on. The question is this. Adam owns Blackacre and Whiteacre. Okay. Adam sells Blackacre to Betsy, but reserves an easement that allows the owner of Whiteacre to cross over Blackacre. Okay, so here's a question. Then Betsy buys Whiteacre and then sells it to Carl. Carl can cross across Blackacre. True or false? All right, give you a few seconds to think about that one. What was that?
No, she was asking if it was working or not.
You guys connecting? Yeah? All right, I'll give you another 10. This question's a little bit tricky. I'll give you another 10 seconds. All right. Where did I drop off last time? Oh, yeah, that's right. I think Aaron was the last one. Okay, Andrew. So let's walk through this one at a time, okay? Adam owns Blackacre and Whiteacre. Okay? Adam sells Blackacre to Betsy, but reserves an easement that allows the owner of Whiteacre to cross over Blackacre. How do we characterize that easement?
That is an easement and appurtenant.
Appurtenant. Very good. So with an easement appurtenant, we have a dominant and a servient estate. In this fact pattern, which one's dominant, which one's servient?
So the dominant estate is Whiteacre because they're receiving the benefit, and Blackacre is servient because they have to let the owner of Whiteacre cross.
Okay, very good, very good. All right. All right, so Miranda, next, right? Here's a question. Betsy buys Whiteacre. At that moment, what happens as soon as Betsy buys Whiteacre? But doesn't she own Blackacre?
She buys Whiteacre.
Right.
Which has the easement that allows the owner of Whiteacre to go.
But does she need that easement? I'm sorry?
Does it matter?
Well, that's the question. Right? So a minute ago, Andrew said that the dominant estate was Whiteacre, and the serving estate was Blackacre. What happens when Betsy purchases Whiteacre?
She has the benefit of the easement.
No. What happens when the same person owns the dominant and...
Okay, then it doesn't, you don't need it because you own it.
Ah,
And
there it
it's
is.
The Blackacre.
Say it again, Miranda, louder, please.
Well, you don't need easement because you have owned both in fee, so they're the same.
Everyone understand what happens, right? When the same person owns both the dominant and the servient tenement, or the dominant and the servient estate, the easement dissolves, right? You can't trespass on yourself. You can't have an easement unto your own land. So effectively what happens is that the easement's wiped out. As soon as Betsy buys Whiteacre, which was the dominant estate, she now owns both. The dominant and serving estate, the easement disappears. So now, Madison, the question is, Betsy then sells Whiteacre to Carl. Can Carl benefit from the easement?
Since it disappeared, no.
She's correct. The easement's gone. He can't cross. It's false. Right? Let's see how we did this one. Ooh, good, pretty good. About 56%. Yeah, the answer is false. And the reason why I want to start off with this question is to teach a principle, right? Easements are not necessarily infinite. They don't always last forever. Different things can happen, different circumstances can happen that can modify whether an easement continues or whether it dissolves or whether it can be modified, right? In different circumstances, easements can be changed. They can be terminated, they can be modified, they can be dissolved, different things can happen. All right, stick with me. So any questions on that? Yeah, the answer there is false. Everyone get that one? Okay. So Megan, let me ask you another question. Here, is there any question that when Adam sold Blackacre to Betsy, the easement transferred over? Is there any question that the easement transferred over when Adam sold Blackacre to Betsy?
No.
Okay, why not? Why is there no question about that?
Because there were two different owners at the time.
Very good. And what kind of easement were we talking about here?
Appurtenant.
Yes, ma'am. Easement appurtenance, an easement appurtenant can be assigned, right? Assigned. Mike, what does it mean to assign an easement?
You're transferring the rights of that easement to another person.
Very good, very good. To assign means basically to sell. right, to transfer. There's no problem with transferring Blackacre with an easement on top of it. You can always transfer property with an easement appertenant. But the rules are slightly different for an easement in gross, right? You can always transfer an easement appertenant. That's not an issue. But the rules are slightly different for an easement in gross, okay? And the first case, which is a little bit tricky, illustrates some of the wrinkles when you try to assign an easement in gross. Okay? All right, so everyone with me? All right, Mariah, I think you're next. You want to give me, please, the facts in the first case, the Miller versus Lutheran Conference and Camp Association from Pennsylvania.
There was an original easement that allowed for fishing and boating, and it was transferred to the Millers. The Millers gave a fourth of that easement to his brother and his business partner.
Okay.
Eventually, there was a foreclosure on the mortgage, and the interest was sold to a company, a separate company.
Okay.
Rufus died, and then his executor tried to give a license to the Lutheran Conference and Camp Association that included not only fishing and boating, but also bathing.
Okay.
And that was the issue, was whether or not they were allowed to do that.
Okay, very good. Thank you. So let's walk through the facts here one step at a time, right? We have a lake in the Poconos. The Poconos is and was, but more likely was, a very popular resort in the Pennsylvania mountains. Beautiful place. Very, very, very cold in the winter. They have skiing there, but in the summer it's a beautiful place. I have some pictures here of people boating in the river or boating in the lake, etc. Okay. So the facts here are a little bit tricky. I want to walk through these one step at a time. In 1895, Frank and Rufus, these were brothers, they leased this land for 99 years to the Pocono Springs Water Ice Company. Now, why is it called the Water Ice Company? This always surprises students. But before refrigeration, the way ice was made was by taking frozen water and keeping it cold. I know that sounds really obvious, but people don't think about it. You would actually go to a frozen lake, chop up ice, put it in a cooler, and bring it to the city. Right? That's how you made ice. There was no refrigeration. So it was called the Pocono Spring Water Ice Company. They would make ice in the winter from this frozen lake, and in the summer they would use it for recreation. Okay, a couple years later, the company put a mortgage on the property, and then Pocono Springs granted to Frank and his assignees the right to fish and boat in the lake. I wanted to stop there for a minute. That's basically an easement, right? The company owns the lake through this lease. It's a 99-year lease. It's not permanent. But for 99 years, the company has basically full access to the lake. The company then grants an easement to Frank for fishing and boating. Right? Now, one thing about easements you have to keep in mind, easements must be precisely worded. They have to be precisely worded. For example, if I say, you have an easement to cross my property by foot, does that mean you can cross it by horseback or by car? The answer is no. When you give an easement, you're giving an easement for a specific type of usage. Maybe you're okay with foot traffic, but you're not okay with a horse because the horses might tear up the grass. And maybe you're not okay with a car because a car might, destroy the land. So if the easement was granted for only fishing and boating, that means you're only giving an easement for fishing and boating. It does not include bathing, or what you might just call swimming, right? So why do they only give an easement for fishing and boating? Who the heck knows? We don't really know. But it is given for that specific purpose. Okay? Next, what happens? A couple years later, Frank conveys to Rufus, his brother, a quarter interest in fishing and boating rights, and also a quarter interest in bathing rights. Now, what does that mean, a quarter interest? That he can only swim 1/4 of the lake? No. What that means is he'll get a quarter or 25% of the profits that are generated from the fishing and boating as well as the bathing. Right? That's what it means. They were partners in business that Frank would keep 75%, Rufus would get a quarter. Make sense, everyone? So, Audrey, at that point, did Frank have the ability to assign any interest in swimming, bathing, at that point?
No.
But he did it anyway. At that point, Audrey, who had the right over bathing in the lake? Sorry? The company, exactly right. So this is a weird situation. For the next 25 years, Frank and Rufus operated a business which involved swimming in the lake. They were not doing that with permission. Right, Max? If it wasn't with permission, how would we describe their use of bathing during that 25-year gap? What word would we use? It was not with permission. It was a trespass. But what specifically do we use in property when you're doing something for a long period of time as a trespass? Right, if they're trespassing every single summer for 25 years, what do we call that?
Implied easement.
No? She's helping, I hear it.
Oh.
That's not how it works. I'll get you another question in a minute. Yeah. The answer is prescription, right? I have very good hearing. It's bad. Yeah. She's read your mind. I guess it's fine. I'll come back to you. It's fine. I'll come back to you in a minute. It's prescription, right? Who's prescripting or who's squatting against whom? Rufus and Frank were the brothers. They were squatting against their own company, right? It's a weird dynamic. But they basically gave the land to this company, and then they're squatting against the company they gave the land to. It's a weird thing, but they're squatting there for 25 years. Right, so Max, I'll ask the follow-up question. Can they gain by prescription a right to access the land after squatting for that many years? Every single summer, same business, running the water and swimming and stuff?
They can.
What are elements?
Like prescription.
Yeah.
Speak continuous for that period of time.
Yeah.
Hostile.
Yeah.
Open, notorious.
Is it all the above?
Yes.
I think so, yeah. So there's no problem with Frank and Rufus basically using adverse possession, that's using prescription, to gain an easement to use the lake for swimming. Now again, they don't need an easement for boating and for fishing. They already have that in writing. What they don't have in writing is swimming. So they've actually gained an easement against their own company, which is, again, it's a weird dynamic, but that's how it works. Okay. So that business goes on for a quarter century. Everything seems fine. But then things go wrong. While this business is going on, the mortgagee, that's the bank, foreclosed on the company, and they sold it to another company, Pocono Pines, Inc. And eventually, after Rufus died, the title vests in Catherine Miller, who is Frank's wife. Okay, so again, Rufus and Frank jointly ran this business for 25 years. Christiana, I think you're next. They jointly ran this business for 25 years. How does prescription work when you have two people who are running the business together for that long? How does that work?
Well, you have to see who has rights, and I know that Frank failed to transfer rights.
Well, we'll get to a second, but who actually acquired the right of prescription? Is it Frank? Is it Rufus? Who actually acquires the right? Why do you say Frank?
They immediately split up.
Ah, that's the question, Christiana. When two people are squatting together for 25 years using this land in a trespass fashion, who actually gets the prescriptive easement?
or not. I would say common sense to me would say that you could split it, but maybe not.
Law school is always the opposite of common sense, right? Tasty, I see you're nodding.
I'd say Rufus got that quarter and then Joy.
Can you split it up?
Oh, no,
Why not?
because they both have to agree.
What's the rule the court identifies? It's a funny name.
It's called the one stock rule.
Yes, ma'am. One stock rule. What's the one stock rule?
So it says if two people acquire a prescription
Very good.
together, it can only be sold together.
Very good. That's correct. Tasty's right. There's something called the one stock rule. It's a weird name, but it's an old common law doctrine that says when two people jointly acquire property through adverse possession, that it's theirs jointly. In other words, think of it like tacking, right? Remember we did tacking with adverse possession? If person A is there for 5 years and person B is there for 5 years, you can have joint adverse possession. But who actually gets the title? The last guy there after the 10th year. This is a slightly different rule. This is when they're squatting together, the two of them, jointly. They've acquired it in tandem, and because they acquire it in tandem, they can only assign it together. Frank can't independently convey it, and Rufus cannot independently convey it. Everyone with me, right? So this is the application of the one stock rule. Catherine and Rufus have a joint interest. If you want to think of it, remember from family law or marital property, like a joint tenancy, right, where they both have to turn the key. Remember that from last semester? It's kind of like that. Not exactly, but it's in a similar fashion. One of them can't independently convey it without the other's interest. So, of course, they do the exact opposite, right? That Catherine, who again was the wife of Frank, gives a 1-year license to the Lutherans to fish, boat, and bathe. So, Elena, at that point, right, when when Rufus's executors try to give a 1-year license to bathe, could they have conveyed that interest? That's right. That's exactly right. At that juncture, when Rufus's executors tried to convey his interest in the bathing, it was not a valid transaction. It can only be transacted as one stock, where both Rufus and Frank, although I think Frank died. No, Rufus died. So basically, the executors of Rufus and then Frank have to convey it together. There looked to be some sort of falling out in the business interests because they seem to be somewhat antagonistic at this point. But the correct way would have been to have it actually unified together. Okay? So therefore, the court holds, right, that they gained a prescriptive easement to swim over the land, over the lake, but they gained it as a single stock, a joint stock. Therefore, to convey that right to bathe, they also need to convey it as a joint stock. That was not done here. Only one of the brothers conveyed it. Therefore, the conveyance to the Lutherans was not valid. Right? You can't divide a joint easement into separate shares. What throws you off is like, oh, he has 1/4, he has 3/4. It doesn't matter. When you have a prescriptive easement acquired under the one stock rule, you can't split it up. Now, this is more of the common law approach. As you may have guessed, the modern restatement third approach is that you can assign partial interests, but just so you know that there are different rules with how these operate. Okay. Is there any questions in the first case? Any questions in the first case? No? Yeah, Anthony.
Okay, so just to make sure hopefully with this one stock rule, essentially it applies if there's two people who essentially gain the
Prescriptive. Yeah,
easement
hard word to say. It is.
Yeah, prescriptive easement together, and because of that, they can't split it up under that.
Yeah, they both return the key. Like it's very similar to a joint tenancy in family property law we did last term. All right, other questions in the first case? All right, Hannah, I think you're next. You want to right here perfectly. You want to give me the facts in the next case, the Voss case?
So there was an easement, with the owner of the could use
Or hold on, let me bring up the picture so everyone can see it. Okay, go ahead, please.
the owner of B could enter and exit through parcel A,
Okay.
but it was only between B and A.
Okay, very good.
And so Voss owned parcel A and Brown owned B and C. And Brown wanted to build a house that like part on B and part on C and wanted to use that same easement to enter and exit on C. Like, this is-
Okay, very good. Very good. Thank you, Hannah. So, we have a situation here, right? Originally, you have 3 lots. You have lot A, you have lot B, and lot C. Lot B was landlocked. What does that mean? They can't get out, right? Now, we discussed last week what happens if you have a piece of land that's landlocked. You can go to court and ask for the court to imply an easement by necessity, right? That it's absolutely necessary to get out, right? Elise, would it be absolutely necessary for B to cross over A to get to the main road?
I think yes, but didn't they say that they also had access to another road?
Yeah, so they could also go out this way to the main road. And there's actually provisions of law which allows the government to use what's called eminent domain. We'll use eminent domain later this semester, but eminent domain gives the state the power to seize or condemn. Condemn is an awful word, but that's what it's used. To condemn land to cross over from parcel B to the main road. So they could have gone through the government channels to use eminent domain to get access to the road, or the owner of B could have simply just paid for an easement to cross over A. And that's what they did, right? They bought an easement. Okay, now this is what's called an easement appurtenant, that the owner of parcel B can cross over parcel A to get to the main road. Right, so far so good. Now, Anthony, when B and A were negotiating, what was the only concern they had? What was the extent of the negotiations when B and A were negotiating?
Well, the extent of the negotiation, however, the previous owners of parcel C were not parties to that.
Okay, very good. When A and B, or let's say when the owners of A and B were negotiating, all they were concerned about was the owner of B getting across A. And that's what's called easement appurtenant. This was not an easement in gross. They could have done an easement in gross. Right? They could have said whoever owns parcel B gets it, or they could have said John Doe, whatever his name is, gets it. But they did an easement appurtenant. James, right? But then things changed, right? What changed? Why did this lovely transaction go awry? Good. And what did he do? What did he build?
He wanted to build a big house.
Big house. Yeah. And it straddled, right? So here's what happened. The owner of B purchased lot C and bought a house, a big house, that straddled the 2 different lines. It straddled line 1 and 2. I'm sorry, lots B and C. So, you may ask Andrews, what's the big deal? Right, who cares? It's still one family driving across lot A to get to the main road. Why does this make any difference whatsoever?
I guess the owners of Lot A, they didn't want that much traffic going through the
That's
easement.
I mean, this much traffic. It's the same person. Whether his house is on one side of the line or the other, it's the same people living there. What difference does it make?
Well, they spent a considerable amount of money, and so they thought that it would create too much of a ruckus, I guess.
So what did the owner of Lot A do that should never be done? The one thing I told you, don't do this because you're gonna lose your case.
He put up like a chain.
Yeah, put up a fence.
A fence
Yeah,
there.
yeah. He put up a chain. He tree stumps, whatever it is, right? He blocked the passageway. And I can tell you, my friends, if you have any easement case and you want to lose, put up a chain link fence, right? You're going to lose because you're going to piss off the court. And especially in this case, where the court basically says, yeah, they were wrong on the law, but we're not going to reverse the lower court. We'll get there in a minute, right? But the number one way to lose these sorts of cases is by putting up a fence and stopping people from accessing a road that they otherwise were able to access, right? That they've been accessing for a long time, and then you put up a fence or a chain or whatever. So let's walk through this argument one at a time, right, Mary? Andrea says that this new house can create additional traffic and create a ruckus. Is that accurate?
No,
No, why not?
because it's the same person for
Yeah.
parcel B. They just lots of.
It's the same damn thing, right? Whether their garage is on one side of the line or the other, it's the same amount of cars. But then, Mary, then why was this case, I think, so difficult, even for the court? What about this case made it a tough case?
I think it's what if the owner of parcel B sold C and built something?
Good. Yeah, so think of it this way, right? At this point in time, it's no big deal, right? You know, the house crosses a border by a couple feet, it's one family. But what if, the court says, we will extend the easement not just to the owner of B, but also to the owner of C. And then they sell lot C. And they put up a condominium, a high-rise. So instead of one family, they're now 15 families. Easement. It's A's title is encumbered to other property. It's encumbered by the easement to lot B, encumbered by the easement to lot C. So if lot C builds a high-rise condo, whatever, then now lot A has to allow them to cross. So the actual legal issue here is one of text. They negotiated precisely for an easement across lot B onto lot A. That's all they negotiated for. Nothing more, nothing less. For the court to extend the easement would further take sticks out of the bundle from lot A's owner. Okay? So the general rule is courts are not going to extend easements that the parties could have negotiated for, right? How much more money could have been given to the owner of lot A to permit the easement to cross over? There's a dollar figure, right? There has to be, everyone has a price. As awful as that sounds, everyone has a price. You give them enough money, you can cross over. Now, the fact that they did it without paying led to all this animosity between the neighbors. But now they just give them a price, they probably have taken the easement and paid for it. So everyone get the rule here, right? That courts are not going to extend easements that they could have been negotiated for at arm's length. But this is a weird case, right? The Supreme Court rules that the law is such that the easement can't be extended. But then at the very end, they say the trial court has broad equitable powers to focus on the injury at hand. And they say the trial court found that the owner would be landlocked, that the plaintiff acted reasonably, there's no increase in traffic, and that the plaintiff would suffer hardship. So then they say that the trial court did not abuse its discretion. The easement should be granted. What? Rochelle, help me out here. Everything was going cool to the last paragraph. What happened at the very end of the case? How did the plaintiff win by losing? What happened here?
I mean, I think that they were trying to say that the trial court didn't abuse their discretion, so.
But did they get the law right?
No.
No. How can that be, Rochelle? How can getting the law wrong not be an abuse of discretion?
I think it's because there was no hardship to the defendants, so.
So let me ask you this question, Rochelle, and I'll be on to Brooke in a minute when I ask this question. Let's say you're a lawyer in Washington, and you want to advise your client, right? Is the rule that they will or will not extend the easement in a future case? What's the rule?
I think the rule is don't put up a fence.
Don't put up a fence. See, she listens. Very good. Right? So, Brooke, let me ask this question, though, right? You're advising your client. What's the holding, then, of this case? That the court will or will not extend the easement? What's actually the holding of this case?
My understanding was they did recognize the rule,
Yeah.
but they didn't want to reverse the damages.
So they didn't follow their own rule, did they?
Correct.
You ever see this before in a case?
Not one that comes to mind. No.
No, I similar. Usually they'll say, well, here's the rule, but, we applied in this case, but we won't apply in other pending cases. But this case is strange, as they say, here's the rule, we're not applying it here, but we'll apply it everywhere else. Yeah, usually it's a very strange case. So I think the dissent, states the issue well. He's like, what happened here, right? The court correctly finds that the extension will be a misuse of the easement, but holds that the owner of the serving estate does not get injunctive relief. Right? But now, Josh, the question becomes, what if in the future there's a hardship, right? What if in the future, in fact, the owner of Lot C builds a high-rise? Is that use permissible?
No, limited it to personal use.
Is that what this case says?
No, that's what the court said under this circumstance.
But does the majority limit this only to the present usage? In other words, if the hardship changes, does this inquiry, in other words, is this res judicata, right? In other words, if they build a Lot C, can the owner of Lot A come back to court and challenge it?
I believe so.
Yeah, I think he's probably right. I don't know. Matt, what do you think? Do you think we have res judicata here, or if an apartment building is constructed on Lot C, that the owner of Lot A can come back to court?
I think you'd be able to go back to court.
And what would he have to argue?
That he had a substantial hardship.
Yeah, I think that the court's opinion here is one of equity, based on the fact that there's no hardship. So if at some point in the future a hardship does, come into existence, I think they could probably challenge this. I think they could. Anyone disagree? I don't have a good answer, but I think they could probably challenge it in the future. Yeah, Brooke, you want to add something?
Just a question. Did you say that the easement is limited to the use for which the original parcel was used for a single family residence?
Yeah.
How does that play into the res judicata argument?
Oh, so you're saying if it's not a single family residence, would the rule change?
No. Pretty much they limited this easement to where only if there's a single family residence.
I think as an equitable matter, that's a good way of reading it.
Okay.
It's a very strange thing, because usually in easements in writing, right? You have an easement, it's recorded with the county, whatever. But here the court effectively extended an easement for a very specific purpose, for this usage. Mm-hmm. But in theory, if the burden changes, this holding may not stay, and then you can go back to court and re-challenge it. Okay. Again, it's a very weird idea, because usually you have res judicata, courts like to settle issues. Mm-hmm. But here I think they said, well, we like the rule, but this guy was a jerk because he built the fence, so we're just going to one-off it and just do this one case, and then hope he doesn't come back later to deal with it. I think. I know. Again, I think there's some language that you could probably go either way in this, but I think that's probably the best way of reading it. Yeah, not a fan of this case. Announce the rule, stick to it. Can't even apply your own rule. It's a bad rule. I mean, they could have just said, the rule is we will extend the easement so long as there's no hardship. That's a better rule. It's actually consistent with what they did. Instead of saying, no, we'll never extend the easement except here. Okay. Anyway. Okay, I think the dissent makes the better of the two arguments. And again, there's notes after the case where Brown called Voss the scumbaggiest person I've ever met and called his wife a bozo. I mean, there's some really, there's some real bad blood between these neighbors. They really seem to hate each other. And this thing dragged on for, 7 years? Anyway, eventually the Browns moved to Alaska. And The owner of B sold it to Voss. They merged and it terminated the easement. And then Brown said, "It's unfortunate we didn't bury him." Oh, God. These people really hate each other. Okay. So, again, as a general rule, the courts will not extend easements beyond the text of what's written. That's the general rule. Okay. Is there any questions? All right. So the last part of our reading focuses on how easements can be terminated. But I want to focus on one element, and they cut this out of your book. I'm not happy about it. They always make changes. I don't like the Martin Brand case, do you? No, I'm not going to sign it next year. I'll teach it, but it's a recent case. I actually read it when it was new. I didn't even remember it because I read it a couple years ago. But it's a recent Roberts Court opinion. You know, there's always this urge to assign the newest cases, which aren't always the best teaching vehicles. I think this is one because there's not much law there. It's like, do you really care about this railroad case? I mean, anyway, I'm probably not going to sign it again next year. But I want to do a little discussion on easement. So the origin of the Martin Brandt case was something called rails to trails. Rails to trails. Anyone ever hear about this? Rails to trails? So the idea here was actually very good. It was very well intentioned. In the 1800s and early 1900s, the railroads were effectively common carriers. They're public utilities. And the railroads purchased easements across the country. Why? To put down their tracks. So the government would come in, they would use eminent domain, and they would basically buy an easement across the back of your lot to put up train tracks. They don't need a fee simple, they only need an easement to cross it. Right? A very, however wide a train is, I don't know how wide a train is, but whatever the width of a train is on either side. Poor old Mrs. Tompkins, right? Walking near the train track. No, I'm thinking Mrs. Palsgraf. Wrong train person. Right. Tompkins was the guy who got hit. Anyway, why is that relevant? Well, trains used to be very important, and they're not very important anymore. So what happened to all of the easements that were given to the trains? Well, in many cases, the railroads simply went out of business, and they abandoned the tracks. Sometimes they took up the tracks for scrap metal. Another time they just left them there and they just went out of business. So at some point in the 1980s, someone in the government had a genius idea. Said, wait a minute. When these tracks are abandoned, the interest comes back to the government. Right? The interest comes back to the government. And here's what we're going to do. We're going to give these easements to the states to build trails, nature trails, right? People can go hiking on them. What a genius idea. Convert the rails to the trails. This was perhaps the most expensive litigation decision ever made in history. Why? If an easement is given for purposes of a railroad, that's a specific purpose. Can the easement then be converted to a hiking trail? So, again, the purposes, right? The easement was drafted for the purpose of railroads. And then, 100 years later, they said, no, we're now going to assign these easements for the purposes of hiking, walking, bicycles, whatever, right? So this brings to mind one of the most famous riddles in all of law school. Okay, so Reed, you're up. So Reed, you come across a sign at a park. And the sign says, no vehicles in the park. Anyone ever heard this before? and you come across a sign in a park and it says, "No vehicles in the park." In fact, I actually saw such a sign. I was in San Francisco by the Golden Gate Park, and he says, "No vehicles." This is actually a very dangerous picture for me. Because see this guy on the bike tearing down the hill? About 2 seconds later, he's like here. So like, I have the other shots. It's a little blurry because I have to run out of the way. The risks I go to get you pictures for stuff, you have no idea. But anyway, so you come in and you see a sign read and it says, "No vehicles in the park." What does that mean? No kidding. So what's a vehicle? So Reed says no motorized thing you can sit in that moves, right? Where do you get? No, I'm not. Yeah, I'm selling you, Reed. Or on your next. I see your name tag in the angle. Reed, where do you get motorized from?
I mean, most of those signs in parks, it doesn't include bikes because, I mean, maybe it has to do with the size of it, and there's no emissions. So when you drive by somebody, you may.
So is it standard emissions or motorized? What's your standard for a vehicle?
I'm going to go with motorized.
Ryan, no vehicles in the park. How would you understand vehicles? I swear there's a reason for this discussion.
I would agree with him.
Why?
Because I feel like, so for instance, whenever you have on sidewalks, the signs say no bicycles on the sidewalks. It doesn't say no vehicles on the sidewalks.
So you think a bicycle is a type of vehicle?
No, I'm just saying where the state, I guess, or whatever you want, like I guess the state wants to clarify they have, as far as like in pedestrian areas or cities or whatever. But
why should the government dispel specificity every single type of mode of conveyance? Why can't they say no vehicles in the park, save on paint? Right, simple sign.
Because then we have this issue. We're arguing over what a vehicle is.
Jake, what's a vehicle? How would we define this term vehicle?
A mode of transportation.
Any mode of transportation. What a baby carriage. Baby carriage is banned in the park?
I think it need to be more specific.
That's all the sign says. That's all you're getting. How would we go about deciding the definition of the word vehicle?
I guess
No, one at a time, please.
I guess like whatever you would infer would be like predominantly like means of transportation.
And how would you get that from, right? How would you understand that term?
Just your surroundings around you. Like,
where would you look for?
Where would I look for?
Yeah, how would you know?
I would look in the community, see if like cars, if there's a community that doesn't use.
So you'd look to practice, right? What if you look in this practice and you see lots of cars driving around this park?
Then I guess I would assume vehicle doesn't mean car.
But the people are maybe breaking the rules. Caitlin, how would you go about understanding what a vehicle is?
I look for like park regulations. And
Park regulations. Let's say they're silent. They don't say no vehicles. They don't define what a vehicle is.
Well, then who put up the sign?
So what if I tell you that the sign was put up in the 1880s, and it's a really good sign, really durable, right? And the sign's been there for 100 years, 150 years. Would that change the way you understand the no vehicles in the park rule?
Yeah, because it goes back to what Jake was saying about what the community defines it as.
Were there cars in the 1880s? How would a vehicle have been understood back then? Bicycle, like the big front wheel, right? Got the handlebar mustache, right? What else? Horses, right? So would horses be allowed in the car or in the park? Okay. So let's say the sign's been there for 100 years, and maybe at one point it was understood to mean horses, and now it's being used in the year 2018. Should the meaning of the sign change over time?
It depends on what you intend the park to be used for.
So Esther, who gets to make the decision then? Right? Can the police just arrest you for, being on those little electric scooter thingies and say that's a vehicle? Say, no, it's not. Who is supposed to decide then what a vehicle is? Well, But what if, you've had these park rules around for 100 years and it's never been enforced? And then you have like a police officer, aha, you're on the little electric scooter thingies. Or Segway, I don't know, right? Who gets to decide?
Well, if that's how the rule is, like it hasn't changed, then the group can decide if that's what they're following.
So how do you then challenge it, right? Police arrest you for riding a scooter. You say it's not a vehicle. Who gets to decide what a vehicle is then?
The people who are in charge of changing the signs.
What if the sign's never been changed?
And what we're supposed to adapt to society. As
Adapt to
society
society.
changes.
So, but the sign's the same, though. The sign has been changed. It's made in wood paint.
Right.
So, Rox, I'll ask you a question. Now, let's go back to the actual issue at hand here, right? If you have an easement granted in the 1890s for a railroad company, and let's just say the easement says this easement can be used for railroad transportation. Could that embrace using the easement for a hiking trail?
No,
Why not?
because the easement was specifically for railroad
Okay.
transportation and hiking.
Okay, so let's just say that the easement can be used for, Roxy, let's just say transportation. Let's say the easement we use for transportation, public transportation maybe. Can you squeeze in a hiking trail there?
Maybe,
Why? Why is it closer?
because that hiking would be a form of transportation, potentially.
So, Edwin, what if it said for a mode of mechanized transportation? Could you then use that for hiking?
No, because hiking isn't better.
Could you use it for cars? Could you use it for cars?
Yeah.
Yeah. So the reason why this little experiment is that's the basis of the Marvin Brandt case, right? How these easements can be understood. And the courts generally held, right? The courts generally held that an easement used for a hiking trail is not consistent with an easement granted for a railroad. So the courts were not willing to update the easements. Okay? The actual issue in the Brandt case, which I don't want to bother wasting time, I think is sometimes I sign new cases and I regret assigning, so I'm sorry about this one. But this one I think is actually fairly straightforward. The court, so Lucas, what was the, just give me the facts then in the Brandt case.
Okay, so this granddad guy, he worked at a small mill in the Fox Park, Wyoming.
Oh, did I skip Costa? I'm sorry.
Well,
Yeah, I think I skipped you. I'm sorry. Please, go ahead. Give us the facts, and Lucas, you're going to call in a second.
So I guess Melvin had a park in Wyoming, and there was a 83-acre parcel of land in the park that I guess had been it was previously obtained by the railroad company in 1908, and then the railway was completed in 1911, and then it was sold in 1987. Oh, and then the action was initiated for seeking a judicial declaration of abandonment in order providing title to the United States.
Okay. So just Costa, just this part let's discuss, right? What happened to the railroad that operated this railroad for a number of years? Yeah, it went out of business, right? So the question is this: what happens to the easement that they had when they abandoned their business? Okay, so Lucas, let me ask this question now. What did the government want to happen when that easement was abandoned?
They wanted to, they had
reversionary, yeah. Right, so good. Okay, very good. So the U.S. government, the federal government, argued that they had a reversionary interest. When the easement, they call it a right-of-way, and I just want, they don't really define this term, I don't think. But a right-of-way is basically a synonym for an easement. It's like the same thing. But the government argued that when the right-of-way was abandoned, it reverts back to the U.S. government. And the property owner said, no, no, no. Justin, what happens when the easement's abandoned according to the property owner? It goes back to the grantor, right, the original property owner. Okay? And so, Justin, what's the holding then of the case? Finish it up. Why? Yeah. Yeah, so that's the rule. It's actually fairly straightforward. In the oral arguments in this case, Justices Breyer and Scalia were talking about their property classes if they hadn't thought this up in 30 years. It was actually very funny. And there was this long discussion of the difference between an easement and right-of-way, and this opinion is not very satisfying. So yeah, the whole thing is when the right-of-way was abandoned, there's no reversionary interest. It goes back to the property owner. That's the whole thing. It's pretty straightforward, and probably not going to sign this case again next year. Although if we do have this new property thing, I don't think I'll be teaching these units. I think I have to condense a bit, which might not be a bad idea. But see what happens today. Okay. More generally, there are several ways to kill an easement, and the book discusses these. One is that the owner can release the easement, right? I'm sorry. You never ring your name tag. Samantha, right? Samantha. Yeah, just get a new one. It helps me learn your name when I can see your face and your name one next to each other. So Samantha, what does it mean to release an easement?
If the person who gave it takes it back or if they agree to stop it.
Yeah, basically means relinquish, right? If you are the dominant estate, you can release the servient estate by giving it away. It's called a release. You'll see this term release in lots of contracts cases. When you release someone, that means you give up any sort of rights or claims you may have against them. Okay? Easements can also expire at the end of a stated period. So, for example, you can give an easement for, say, 10 years, and after 10 years, the easement dissolves. We also discussed with easements by necessity. The easement only lasts so long as the necessity exists. If the necessity no longer exists, it goes away. So, for example, if a new road is built that allows a landlocked piece to get to the main drag, the easement dissolves. There's also the issue of merger, which we discussed at the start of class today. If the same person owns the dominant and the servient estates, you have to be simple. There's no more easements involved. There's also something called condemnation, which is eminent domain. The government, if they need, they can use the power of eminent domain to seize part of your land and to get an easement across it. Okay. All right, so any questions on that? All right, so let me summarize a bit and get it early again. This class is shorter than I expected. I'm sure none of you will object. Generally speaking, easements appertenant can be assigned. Easements in gross under the common law cannot be assigned, but under the modern rule, easements in gross can be assigned. And when you have abandonment, the courts generally will not give a reversionary interest. And when you have an easement that's for a specific type, courts will not expand it further. Your reading for Wednesday starts a new topic, covenants. Covenants is probably the most difficult aspect of the semester. This is like future interest. It's probably the hardest part. So make sure you read the cases very carefully. And make sure when you come to class, you can distinguish between an equitable servitude and a real covenant at law. Make sure you know the difference between an equitable servitude and a real covenant at law. Any questions? I will see you all on Wednesday. Thank you very much.